Hey everyone, welcome back. There's a shift happening, not in whispers or backrooms, but in courtrooms and federal filings. And what's at the center of it? A challenge to one of the most entrenched laws in American firearms regulation, something that, for nearly a century, has defined how certain weapons are tracked, taxed, and controlled by the federal government. But the ground beneath it is starting to crack. It all goes back to a bill that made headlines for many different reasons. Touted as a sweeping reform package, the One Big Beautiful Bill Act, signed into law on July 4, 2025, dealt with everything from fiscal policy to border enforcement. But hidden deep in its text was a provision that didn't receive much attention at first: the complete repeal of the $200 transfer tax on certain firearms under the National Firearms Act, suppressors, short-barreled rifles, short-barreled shotguns, and other classified weapons. It was a sentence, maybe two, buried in a document hundreds of pages long. But that sentence has teeth. For decades, that tax wasn't just about revenue. It was a gatekeeper, a deliberate deterrent, a way to control ownership without issuing a ban. It came with forms, fingerprinting, background checks, months-long waiting periods, the sort of process that made people think twice, or three times, before even attempting to comply. It became a way to regulate by inconvenience, rather than by outright prohibition. And in doing so, it shaped the behavior of gun owners across the country. Now, that tax is officially scheduled to vanish on January 1, 2026. That alone might sound like a victory to some, but the reality it leaves behind is messy, because the tax may be gone, but the rest of the system is still standing. You still need to submit your personal information, still need to be tracked, still need to wait. In essence, the government is keeping the chains, just cutting the price tag. A registration system built on the justification of taxation continues to demand compliance, without the tax that once made it legally viable. That contradiction didn't go unnoticed. On August 1st, just weeks after the bill became law, a federal lawsuit was filed in Missouri that cuts straight through the core of this issue. It's not just procedural, it's not symbolic, it's structural. And the argument it makes is both bold and, to some, obvious. If the tax is gone, the legal basis for this entire registration regime disappears with it. Federal agencies aren't designed to operate on phantom authority. When a law shifts this dramatically, the systems built on top of it either adapt or they fall. Whether that happens here is still uncertain. But the challenge has begun, and it's already stirring debate in every corner of the legal, political, and gun rights world. The people behind this challenge are no strangers to federal courtrooms. This case, filed in the Eastern District of Missouri, isn't the work of one frustrated gun owner or a regional lobby group. It's the product of a coordinated legal front composed of organizations that have long fought against regulatory overreach. National groups like the Second Amendment Foundation, Firearms Policy Coalition, American Suppressor Association, and the National Rifle Association are all standing together. But they're not alone. Two individual plaintiffs, ordinary citizens, have also joined the case. Alongside them is a black-owned gun store based in Missouri, Prime Protection STL, which has never sold a single NFA-regulated item. Not because of lack of interest, but because of what they say is a deep distrust of the federal government's data collection process, especially among their local community. They all say the same thing. What's left of the NFA's regulatory framework no longer has a constitutional leg to stand on. And their arguments aren't speculative or theoretical. They're built on precedent, legal history, and the clear language of the Constitution. When the National Firearms Act was passed in 1934, it wasn't marketed as a prohibition. It was a tax law, a workaround. Lawmakers wanted to discourage ownership of certain weapons without invoking a constitutional ban. That $200 fee, a huge amount at the time, did the trick. And when the law's constitutionality was challenged in court, the Supreme Court upheld it on the basis of Congress's taxing power. That justification mattered. It was the only thing propping the whole thing up. But now, that pillar is gone. With the tax eliminated, all that remains is a regulatory framework pretending to be lawful, without a financial component. The original justification under the taxing clause collapses. What's left is a system demanding compliance, fingerprints, photographs, and wait times, but offering no constitutional rationale for doing so. Even if the federal government were to shift and argue that the NFA is now justified under the Commerce Clause, Precedent again steps in. Courts, including the Eighth Circuit, have previously ruled that the NFA's registration requirements can't be propped up by interstate commerce claims. And that's not just academic legal theory, it's settled case law. Then there's the Second Amendment itself. In light of recent Supreme Court decisions, especially the landmark Brewing ruling, any regulation that burdens a constitutionally protected arm must be supported by a historical tradition of such regulation. And that's a problem for the government, because there is no such tradition. There was no colonial-era registry. There was no founding-era bureaucracy demanding documentation before a citizen could own or transfer their firearm accessories. In fact, even during times of unrest and rebellion, personal arm ownership remained private and unrecorded. If registration didn't exist when the Second Amendment was ratified, the logic goes, it shouldn't exist now. The NFA's requirements aren't just outdated, they're unconstitutional. If the court agrees with the plaintiffs, the outcome would be immediate and sweeping. The burdensome system that has long required law-abiding Americans to jump through administrative hoops for months, sometimes years, could be dismantled. Form 1s and Form 4s would no longer be required for items like suppressors and short-barreled rifles. The fingerprinting, the background checks, the long delays, and the slow, opaque approval process would vanish along with the legal justification that held it all together. It would mean the end of treating peaceable citizens like suspects for simply wanting to reduce hearing damage at the range or customize the size of their firearm for lawful use. More than that, it would break the assumption that the federal government can indefinitely demand personal data and compliance without a clear constitutional basis. That's not just a technical win, it's a cultural and philosophical one. For many, the idea of firearm registration conjures up concerns far beyond simple red tape. It's about precedent. It's about the slow normalization of surveillance. When laws once rooted in revenue collection mutate into mechanisms of control, unchecked and unquestioned, they begin to erode public trust. This lawsuit doesn't just challenge a statute, it challenges that erosion. It calls out the creeping scope of federal power and demands a reset grounded in constitutional principles. The arguments raised in the case don't exist in a vacuum. They're part of a broader national conversation about what regulatory authority looks like in a post-Brewing legal environment. Since the Supreme Court reinforced the history and tradition test for gun laws, courts across the country have had to re-examine modern firearms regulations through an 18th century lens. Some laws have stood, many haven't. If the NFA's registration scheme falls, it may set a precedent that reshapes not only how the ATF operates, but how future laws are written. It could strengthen judicial scrutiny on licensing delays, bans on certain accessories, and even digital surveillance tied to gun ownership. That ripple effect is what makes this case more than just about silencers or short barrels. It's about the structure of gun law itself. Whether the challenge ultimately succeeds remains to be seen. Legal fights like this move slowly. They stretch across months of filings, responses, motions, and appeals. But the filing alone, the willingness to confront federal authority with organized, well-supported constitutional arguments, is a shot that can't be ignored. No matter where you stand politically, this case marks a pivotal moment. It invites every American to look closely at how law evolves, how power is used, and where the limits of government should lie. For some, it's about reclaiming rights. For others, it's about demanding clarity. Either way, it's a fight worth watching. Stay aware, stay engaged. I'll catch you in the next video.